We're going to get started. I'm Adam Liptak. I cover the Supreme Court for the New York Times. And before I tell you who's with us tonight, let's reflect for a moment on someone who's not. Last year, Walter Dellinger was on this panel, and for so many years, he was a leading member of this community, a great student of the Supreme Court, the liveliest legal mind I've ever met. Let's pause for a second to recall him. So we have a murderer's row of Supreme Court experts with us today. I'm going to introduce them going right to left. Roman Martinez is a partner at Latham & Watkins, a veteran of the SG's office, a former clerk to Justice Kavanaugh when he was on the circuit, and to the Chief Justice, and perhaps most notably, he was the advocate at the Supreme Court during whose argument a flush toilet was heard. If I ever get to write your obituary, Roman, that will be the
Thanks.
little dab of color in an otherwise sober career.
Yeah.
Melissa Murray is a professor at NYU, a co-host of the Strict Scrutiny podcast. According to press reports in the New York Times, was considered for the most recent vacancy on the Supreme Court.
But see the podcast.
Clerked for Justice Sotomayor on the circuit, and I've been on the occasional Zoom call with her, and I can attest to what Room Rater says is that her background is a consistent 10. Jeff Fisher, of course, is a law professor at Stanford and a director, along with Pam Carlin, of the Stanford Supreme Court Litigation Clinic, and a former clerk to Justice Stevens. Erin Murphy is a peripatetic lawyer, goes from firm to firm. Currently, unless something has changed, she's at the law firm of Clement and Murphy. As argued notable cases in the Supreme Court and clerked for the Chief Justice. And then Irv Gornstein, a veteran and mainstay of the Solicitor General's office, is executive director of the Supreme Court Institute and moots every single case in the Supreme Court term, and therefore probably knows more about the court than any of us. So let me start with you, Irv. Reflecting on the term just concluded, what the hell happened here?
Well, Dobbs happened. A lot of us were wondering what was going to happen in the coming term, and the reality is, a lot happened, but really, Dobbs is the only thing that happened. People care about a lot of the other cases, and they should care about a lot of the other cases, but if Dobbs hadn't happened, it wouldn't have been the term that will always be remembered as the term in which Roe v. Wade was overruled.
And what does that tell us about the court, that in its first full term with a 6-justice conservative supermajority, it should have been so impatient and ambitious to take this enormous step?
Pass. Let's let somebody else answer that one.
Is that right, Melissa? The only thing we should care about here is Dobbs?
I think it's natural to focus on Dobbs because it was such a cataclysmic event. But I think if you focus exclusively on Dobbs, you miss the degree to which the entire term was actually quite cataclysmic and really moved the court assertively to the right and doctrine assertively to the right. We saw a number of cases involving religious freedom. We saw more parries with the whole question of the administrative state. We will see more of that going forward. And I think it was, as Justice Sotomayor put it, the stirring of a young and restless court in true soap opera fashion. And I think we are only beginning to wrestle with what the aftermath of this term and this court will be.
Erin, what say you?
So, I mean, I think I agree with that. You can't completely, look, Dobbs is the biggest thing, obviously, that happened at the court this term, but there's so much more that's going on that is very interesting, that is sort of wholly apart from particular outcomes. I think, to me, one of the biggest stories of this term is looking across all these cases and getting a real sense for, this is a court that not only are there several justices who really view the legitimacy of the institution through the lens of kind of thinking about methodology and thinking about the way they approach cases, but we got a very strong view of how they think they should approach cases with, not just, across Dobbs, across Bruin, across the religious liberty cases, Establishment Clause cases, that this is a court that is very focused on the idea of thinking that they can really look through most of constitutional law through the lens of text, history, and tradition. And that is, that is kind of something that's been coming for a while, but we now have, a majority of the court that seems pretty committed to that. And that, wholly apart from the outcomes here, is really, I think, momentous and something that'll be fascinating to watch kind of where it goes in lots of other areas in the coming years.
Can I jump in on that? Sorry.
I was going to say, Roman, when I wrote my end of term story, I consulted with you, and you made a similar point to what Erin just made, that originalism has really come to the fore. Justice Kagan, in recent remarks, says that's true so far as it goes, but she doesn't understand why originalism is not kind of an opportunistic doctrine that just leads you to conservative conclusions.
Well, I think so. The point I was going to make actually is a good answer to that question I hadn't heard yet, which I think Erin is right. I think one of the things that we saw this term was the sort of framework and the way that the debates seem likely to go when advocates are up there making their case is going to be within an originalist and textualist framework to a much greater degree in the past. I actually thought the argument tonight was a perfect example of that, because I thought that both advocates were phenomenal. But the arguments that they were making on both sides were really about the text, the broader structural provisions of the context, a sort of intertextualist or intratextualist approach, looking at the history. And it was really a very well-developed set of arguments on both sides of this sort of tricky case that were within this originalist and textualist framework. And to me, that sort of suggests that getting to methodologically to a court that's originalist is sort of the first step, but then in each individual case, you're going to have to argue it out, and you're going to have to argue in that language and using those types of arguments. But there are going to be strong arguments on both sides. I don't think that originalism or textualism require one side to win every case. We'll see what happens as the court goes forward. I think Justice Kagan is right to hold originalists and textualists, keep them honest, and push. And I think advocates on both sides can do that. But I think the methodologies are both legitimate and legitimately believed. And then, this is going to be the language the court's speaking. And I think both sides in these cases are going to have arguments that they can make that will appeal to justices on these grounds.
Jeff, some of the big cases early in your career were originalist cases. And they really reshaped the law in some important areas. But I wonder what you think about where originalism is heading these days. And maybe to repeat myself a little bit, is there a flavor of using it to achieve goals rather than applying it as a neutral principle?
Well, I suppose I felt some semblance of that in the Dobbs case, the way it was written by Justice Alito, who I've never really thought of as an originalist. I don't know that you can say the whole conservative majority is originalist, because it wasn't that long ago that the case that leaps to mind for me is the GPS tracking case, which I think was a moot in this room about a decade ago. And Justice Alito, I think an oral argument was sort of mocking the originalist approach to answering whether attaching a GPS device to somebody under the carriage of a car was a search under the Fourth Amendment. He said, are we supposed to imagine a tiny constable under a horse carriage and ask what the English common law judges would have decided? And I don't know that he's really necessarily changed his mind about that. And, even this past term, I take another example of the Texas sovereign immunity case, the USERRA case. Justice Kavanaugh, at that oral argument, in an area of law that originalism gets thrown around a lot, asked only questions about the pragmatics of excluding the state from damages actions under that statute. And so I think some of the conservative majority, I don't want to be casting aspersions, but I think that originalism is attractive in some places, but maybe not as the driving force for their decision-making in other places.
Let's return to Dobbs for just a second, and let's return to Irv and Dobbs, but only in this sense. There's been a lot of dispute about whether Dobbs suggests that other constitutional rights are at risk. And I'm not sure how to think about that. I understand Justice Alito wrote a sentence assuring us that they are not. But the logic of the decision and Justice Thomas's understanding of the decision take us in a different direction. What's the right way to think about what happens next?
So let me elaborate, I think, in answering this on what Jeff said. I think there are varying levels of commitment to originalism among the various justices. And the justices that matter right now are Justice Kavanaugh and the Chief Justice. And so if you ask me, are they going to apply the originalist methodology to overturn the right to marry? I'm going to tell you, there is no way in the world they will apply a originalist methodology to overturn the right to marry.
But do you think they would have voted that way to establish the right to marry?
No.
So they would have applied. So it's a precedent thing.
No, I don't think it's not just precedent. It's what it would mean in the world today.
But 5 years ago, they both would have applied the originalist methodology and would have said that there's no right. And now I think you're probably right that they probably wouldn't.
Yes, but
the precedent is the difference.
It's
right?
not precedent. It's what it means in the world today to people.
Well, is it the reliance? Is it the reliance?
No, I don't think it has a lot to do with reliance. I think it has a lot to do with the acceptance of the broader community to a decision like that today. It would not be a
70% of Americans who accepted Roe versus
So I do think that Roe was a special case, and that look, there was a long history and a long movement, and there would not have been, I'm not going to say that those nominations, that anybody said anything, the last three, about how they would vote on those decisions and that decision, but I will say none of them would not have gotten those nominations unless some people who mattered assured other people who mattered about what their votes were going to be on that decision. And that's just not true of anything else.
How sanguine should we be about this, Melissa?
I was one of the people in 2018 who said that Brett Kavanaugh would be a reliable vote to overturn Roe versus Wade. And I said the threat was neither hypothetical nor hyperbolic. And I was told that I was a fear-mongering hysteric. Now I'm right. I will say I was right the whole time. It could be the case that it is exactly right that we will not see a threat to this in the foreseeable future, 5 years, 10 years. I will note there's a case, 303 Creative versus Elenis, that brings to the fore the question of whether same-sex couples can expect different treatment in the public sphere coming up in this next term. And I think once you begin the process of normalizing differential treatment for same-sex couples, it's only 10 or 20 years before you can plausibly overturn the right to same-sex marriage, because that's the same move that was made with regard to abortion. So this doesn't have to be an immediate prospect. It can be a more incremental kind of endeavor, as it was with abortion, but it doesn't mean it's not going to happen. And it doesn't mean that the interim period between when it happens and now isn't going to be painful for those who are affected. We haven't even talked about the threat to access to contraception. And I actually think that is the more imminent threat, because if we no longer have a federal right to abortion, now the issue is what constitutes an abortion. And there has been a longstanding campaign to categorize and recast certain forms of long-acting contraception as abortifacients. And that to me seems to be the most immediate threat. And it's one that I think we should take quite seriously. So I actually take this court at its word. And no, Justice Thomas may be in the wind on this one for now, but that concurrence will be farmed out to his acolytes on the lower federal courts, and those views will be normalized, and they will make their way back up to the court again. And I'm confident that it will find more than one receptive audience.
Well, I think it will find 2 more votes, but I just do not think that either the Chief Justice or Justice Kavanaugh will be voting to reverse any of those other decisions.
But that's realpolitik. That's not law, right?
Well,
As a matter of law, there is
so I,
It is. It's called precedent. I mean, it's not that hard, right? I mean, it's your point, right? Or you agreed that they would do it one way 5 years ago and they do it differently now in part because the decision's gotten acceptance, but that's a traditional consideration that you would weigh when assessing precedent. Precedent's part of the law. Now, obviously the Dobbs decision came out the other way on precedent, but that doesn't mean that every decision has to be thought of anew from ground up just because you overturn one precedent.
But are you saying that Dobbs came out the other way because it was not as accepted or something? Or why would they do one thing with Dobbs?
I mean, I think the history of these people, the people on the court, the way they've thought about the abortion issue, the way the abortion issue has been contested for 50 years, I think it's completely different.
Mm.
And I also think the reliance interests are significantly different when you're talking about people who are married and saying that they're no longer going to be married, as opposed to something like abortion. I think that it's a different type of, I recognize there are good arguments on both sides of reliance, but I just think it's a different type of argument in that context. Maybe I'm wrong, but I'm with Irv on this.
So the collective reliance interests of married couples is prioritized ahead of the reliance interests of millions of American women who have counted on this right being available.
I'm not giving my own views. I'm just explaining.
Dinner for something I got right.
I think the jury's still out on that one. No, I think
No.
I think that from the perspective.
I think there's a dinner coming.
Well, I will take Melissa to dinner anytime, even without listening to that. But no, I think that the reliance interests do cash out differently because of the fact that even anyone, whatever your views on Obergefell, I think everyone would recognize that taking someone who's currently in a marriage and telling them that their marriage no longer exists is a huge deal and is enormously transformative in a way that's just fundamentally different
Like
from taking
becoming
away
a
other
parent
rights.
is against your will, isn't
But you
it?
wouldn't-
Transformative.
Maybe we could talk about it over dinner.
You have to get me a babysitter first.
I mean, I suppose it's possible to let people who are married stay married, but allow states not to marry other people.
I mean, we can you guys can all come up with great ways to overturn Obergefell. I just don't think it's going to happen.
yeah, it's not.
It just seems to me that I think it's admirable to try to work through the stare decisis factors, but it seems to me more likely it's just sort of a force of will kind of question. And how far do they want to go? That just seems to me.
But isn't there always an aspect of that to stare decisis? I mean, like everyone on the court overturns precedents when they feel they're really, really wrong and really, really important.
Stare decisis is an inherently discretionary. There's a lot built into it. I think anybody would struggle to come up with a right or wrong in some objective way answer to any stare decisis question. So, I mean, there is a certain degree of realpolitik to all of it, but I think the important takeaway is what we do know at this point is there are not 6 justices up there who don't believe in stare decisis, period. There are a couple, but there are not 6. So it's still going to matter in many of these cases.
And let me pursue this theme of whether there's an opportunistic aspect to the court's work. And Ramon, tell me where the major questions doctrine comes from.
Great question. So I think, as I understand it, and I look forward to being enlightened at tomorrow's panel, as I understand it, the major questions doctrine arguably comes from 2 places. First, it comes from a practical construction of statutes and a practical understanding of likely assessment of legislative intent. That's what the Chief Justice said in his opinion. That basically when you're looking at a statute and it's got some vague language that might superficially be read or literally be read to be extremely broad, that as a practical matter, we don't think Congress actually intended to delegate this certain authority. So if an agency goes and takes this facially broad, potential grant of authority and comes up with a new program that's transformative of the national economy or does some other major thing, that's just not something that we think Congress actually intended to authorize. So it's a kind of intent principle. It's a kind of statutory construction principle. I think there's another sort of justification.
Could I just ask you, is that inconsistent with your idea that there are 7 members of the court who are textualists?
I think that it's not inconsistent with that idea, but I think
not if you're relying on Congress's intent.
I think there's a debate within textualism about a literal textualism and a non-so-literal textualism. I think we saw that debate in the Bostock case. And I think there are some justices on the court who would take certain, very broad grants of language and would say that just because I think the quote from the FCC case is you don't just take a word and go to the outer limits of its definitional possibilities. And I think there's within.
Well, but then they would go to structure to figure it out. They wouldn't try to imagine what Congress's intent was.
Well, I think here what they're saying is that you would think that if Congress were going to give an agency the power to solve climate change or regulate tobacco or whatever, that Congress would be more explicit about it. I think it's a kind of, I don't think that's an anti-textualist move. I do think that Justice Gorsuch's vision of the doctrine is a little different, which is really grounded in constitutional avoidance type concepts. And I think that on the right side of the court, the justices who would embrace this, I do think there's a little bit of tension in the way they've talked about the doctrine. And I frankly think it would behoove the court to kind of be a little bit clearer about what they mean, because I think some of the criticisms Justice Kagan has put forward are pretty powerful criticisms that deserve, coherent answers.
When we were here last year, we were focused on the shadow docket. And there was a lot of action on the shadow docket, and that continued into this year, but it seemed to become a little more orderly. From my perspective, importantly, they started to be issued during business hours. Some of the cases made it onto the merits docket and were argued, which I suppose is a good thing, although it makes you wonder whether people don't just have one more way to game the cert process. Erin, what did you see in the shadow docket this term?
Well, I think the court, I think they've taken seriously some of the criticism that they've gotten about it. And I think that's why we saw some of these cases get granted. You can then have a debate about whether it actually is a lot better to have everybody brief and argue cases in a couple of weeks versus in, it's really a couple of weeks usually on the shadow docket anyway. So you're just sort of adding a couple more dockets. But I think the court has taken seriously the idea of, look, let's give, if there's a critique here about the process, then let's make the process seem a little less shadowy and get it out and have briefing and argument, even if that, comes at a little bit of pain for a lot of advocates who had to do a lot of things extremely quickly. But hopefully it is creating a little bit better deliberative process. I do also think they've made an effort to, maybe this kind of is an effort in both directions to provide, to say more in the context of the shadow docket, to say more in these decisions and call colleagues out when they think that they're kind of making law and all of that, which is itself part of the whole process. So, there's sort of 2 critiques that can go on about it. One is, should you not be making law and deciding big things in that context? And another one is more just a process context. And I think at the very least, the court has been, trying to be responsive to the process piece of it. And probably, many of them don't share the views about the critique about the substance piece of it.
Other thoughts about the shadow docket?
I think one thing, I agree with you that it has become more orderly, and I think Erin is right. It is likely because of public scrutiny of the shadow docket. But I think what we're seeing now in the lower federal courts is sort of the aftermath. There's this whole cohort of cases from the shadow docket, much of it quite consequential, especially with regard to the decisions on COVID and state restrictions on COVID and how that might relate to other kinds of state emergency powers. And, the question is, how do you treat those decisions? Are they supposed to be precedents? Are they not precedents? And I think right now, a lot of the lower courts are trying to figure that out. And, we saw the Ninth Circuit get rebuked last year by the court for failing to regard a set of precedents on COVID as precedental because they were on the shadow docket. And so I think there isn't guidance to how that body of jurisprudence is supposed to be used, and lower courts don't really know at this point. So that's sort of, I guess, the long tail of the shadow docket.
Well, I mean, I think that might lead to my perspective on this, which is if you're getting criticized for what the court was doing, it kind of had two options. One is to have more process on some cases and put them on the merits docket and slow them down a little bit. And the other was might have been just to go back to the old fashioned stay factors and the equitable considerations that, in large part kept the court out of this business for all these years. I know there's some new forces that the court is not in control of, but I think the court could have gone in that direction too. I might have preferred that, but I would put a vote in the column that I do think the extra process can matter. I'm not sure I can give you a tangible example of that quite yet, but I do think the difference between, a few days and even if it's weeks coupled with an oral argument and a little bit more deliberation and opinion writing, I think could make a big difference. And, when I've talked to former students who've clerked, and not about any particular case, but just about the phenomenon of the shadow docket, I think that my understanding is just anything that slows things down a little bit and gets people digging in and thinking harder would be good. So I'll cast a vote for that.
You sort of had that sense in that series of cases about death row inmates wanting access to pastors. When they finally set it down for argument, they more or less settled it, it seems. And before that, it was a dog's breakfast of cases pointing in different directions. What about the cert docket? Does the 6-justice conservative majority influence the cert process? I would have thought that at a time when you weren't really sure where Kennedy was, there might be more strategic behavior at conference and voting on cert. Is it different now, you think, Jeff?
I think it's different possibly in two ways. One is the way you allude to, which is if there's doubt about how a big case is going to come out, people might hold back. And now if you have a 6-justice majority with room to spare, I think there might be a little more confidence to grant big cases. And maybe Erin, could give the example of the Second Amendment case from New York as maybe a poster child there. I think it also matters potentially, and one thing I'm going to be watching in the other direction, which is, there's always been 4 more liberal justices that could force a case onto the court's docket. And maybe not the biggest case of any given term, but just workaday error correction cases and civil rights and capital cases and the rest that would still have a meaningful impact on lower court jurisprudence, because they'd be like, oh yeah, Batson, yeah, that still matters. We better get back to business on that, for example. And I think with the inability to force those kinds of cases onto the court's docket, that might end up, if they're on the docket, as 9-0, 8-1 type cases, but just might be absent from the court's docket. I think that could be a big difference in the 6-3 breakdown.
Other thoughts on cert? So as Jess alluded to, and humorously, but it's a real thing, the leak of the Dobbs decision really seemed to be wrenching at the court, and it continues to have a kind of aftermath and blowback. What do you think it did to relations at the court and to the life of the clerks and to where the court goes forward now and how the justices are getting along? Do you have any thoughts on that, Ramon?
It's sort of hard to speculate. I don't really know, but I guess my impression from having interviewed a bunch of the clerks and trying to get them to leak more about the leak. I get the impression it was a very difficult stretch and it was an unusual stretch, but I also think the court is, it is fairly resilient. And I think you have 9 people there who are going to have to continue to work together, and they're going to have to continue granting and deciding cases. And so I kind of think this is an unpleasantness that hopefully there's not going to be a leak every year or more leaks. But if they can avoid that, I kind of think it more or less settles back down to normal. But I think it's a terrible thing. And I think it'd be very interesting if they if there's an actual report that's coming that is going to somehow be made public, that's going to actually shed light on what happened.
I think there may be a report coming.
Yeah, no light will emanate from the report. You don't think?
I don't know what the report will say, and I don't know whether the report will be made public.
Bill Barr will tell us.
So Justice Thomas has spoken publicly about distrust emanating from his end. I think more significant actually is the dissent in Dobbs in terms of relationships among the justices, because that dissent said in no uncertain terms that that was a lawless decision and that it was made only because 5 justices could make it so. And the only difference between prior law and this law is that there was a change in the composition of the court. I think that feeling is unhealthy for the court. And I mean, the relationships among the court, if you feel your colleagues are acting lawlessly. And whether that will carry forward into other cases, I don't know. I mean, I think there was a feeling that that was true in Bush against Gore. And it hurt the relationships among justices in the court for a period of time. The court recovered from it. The question is, will the court recover from this when coming up each term are a series of big cases in which, you know, overrulings are being asked for, and you get, if you end up with 6-3 overrules, that could lead to one result. If you have a situation where there aren't overrules always, sometimes there are, sometimes there aren't. A term of bankruptcy cases might help, but right now I do think there's a potential for ill will carrying over into this term and into future terms.
Does that manifest itself in some concrete way, or are people just grumpier with each other?
I think the way that I would worry about it would be an increased siloing within the court and not as much conversation across chambers in a way that then results in fewer compromises and fewer narrower decisions.
Mm-hmm.
Can I? Oh, sorry. Go ahead.
Well, I was just gonna, I mean, that's where I think there's a little bit of a difference between the impact of the Dobbs disagreement and the impact of the leak. I mean, you know, it's not like it was lost on anybody that it was going to be a big deal and acrimonious for the court to overrule Dobbs, to overrule Roe. You know, I think the conservatives went in like appreciating that. But you know, the leak, I worry about it having some other impacts in ways. You know, what I really hope it doesn't do is kind of make all of the justices like even more sort of insular about their relationships with their clerks, with other justices. You know, I don't think there's anything wrong with justices who care a lot about having people that clerk for them that share their ideology, but I also think it's healthy for the court to have a mix of some justices who care a lot about that and some who care less about that, and just to have a little bit you know, less of that feeling of everybody's sort of on, you know, you're on this team and whatever, and we don't kind of all come together. And I worry that the distrust that this creates as between justices and clerks may undermine some of that, you know, that ability of the clerks. So at least they're coming in kind of fresh and don't always have 100% of the baggage that their bosses have from the year before, of that ability of them to find the cases where they are, you know, sometimes we're going to cross aisles and we're all going to be here together, and not everything has to be kind of what team are you on, and I'm, you know, so in here just with my boss that I can't be trusted to have the kind of conversations that are really important to being a good clerk and building those relationships and doing a good job in that year that you have up there.
Can I ask a question of Irv? I hear the point about the perceived incivility of the dissent. How should that dissent have been written so as to enhance the collegiality and the norms of etiquette on the court?
So I hope you didn't.
I'm just asking.
No, I understand me to critique.
I'm just trying to if we could expect the majority to come out in the way that it did with an historical opinion, an originalist opinion? Why wouldn't the majority have expected their colleagues to respond in kind, that this was really political machinations dressed up as history? Like why would that have been viewed as uncivil? Why wouldn't it just have been expected?
So I think when you're accused of being lawless, you're likely to take it personally. That's just my, now, you know, when it comes from somebody. Now, I'm not saying there's anything wrong with accusing the majority of being lawless. I happen to think the majority was very close to being lawless. But so I'm not saying I wouldn't have, you know, joined a dissent like that.
My point is, like, weren't they already at loggerheads even before these decisions were written? Like, I mean, is this really going to cement bad feelings? It seems like at oral argument, they were pretty much at each other's throats already, and they'd given up on any possibility of compromise.
Yeah, so you know, maybe they were already saying at oral argument what they were writing in dissent. So I'm not saying there was a difference between oral argument and the dissent. All I'm saying is the dissent represents a statement of a kind that I haven't seen in that group's dissents before. And, you know, Justice Scalia wrote dissents like that. And I think people would just say, that's Justice Scalia being Justice Scalia. And they would just blow it off. You know, Justice Alito occasionally writes like dissents like that. You know, even his dissent in calling out Justice Gorsuch for his majority opinion had a flavor of that. But I think what's unusual is when you see the three justices who have never written like that in dissent before, calling out the majority as lawless. I would say it feels different to me because it's not just blowing off steam. It's what they, you know, this is something they felt about this decision and no other. Now, whether they'll continue to see other decisions like this term, there's 3 or 4 or 5 big cases coming up this term. If we see 6 3s in every one of those cases, we may see a continuation of that.
I think that it goes to the point that I made first, which is that it could look like this is sort of the entire breakdown, and this decision is the breakdown of everything if you focus exclusively on Dobbs. But I imagine they wrote that dissent recognizing it wasn't just Dobbs, it was Dobbs and Carson and West Virginia versus EPA and all of these other cases where the court is moving assertively to the right without regard to some of these principles. And the Dobbs opinion captures it, but they're talking about the entire term. That's how I read it. It's this one case, but it's also about the direction of the court itself. And it's not necessarily for their colleagues, it's for the rest of the country. It's the audience outside of one First Street. And so I don't know that they care about collegiality because they're trying to alert everyone to what's going on and that it's more than just this one case. It's what this entire court is doing.
In recent days, the Chief Justice and Justice Kagan have each addressed legitimacy. And I struggle with trying to understand what legitimacy means and what the loss of legitimacy, what the consequences of that are. The chief said one thing, and the two seem to be talking past each other in a way. He said, I understand people are unhappy with some of these opinions, and they're right to criticize us. We're open to criticism, but I don't see how that unhappiness leads to a reduction in our legitimacy. Justice Kagan, stressing that she's not talking about any particular case because she was talking about Dobbs, said the court risks losing legitimacy if a mere change in personnel will get you a different result. And that, so far as it goes, makes sense to me.
How can that possibly make sense? I mean, the whole point is when you have different justices, they're going to have different views and different ideology. It can't be that it's illegitimate just because like somebody came on who thinks differently.
So if President Trump says, I'm going to appoint people to the court to overrule Roe v. Wade, and he does, and they do, that seems more political than law to me.
I mean, why? I mean, what if they just are reaching the result because they think it's legally correct, just because someone like appointed them in hopes that they would do so? It's political, not law.
Well, I think, Erin, I think you're right insofar as it goes that different people are going to vote differently. I think it's back to the stare decisis conversation, though. It's when
Sure.
it's when
And that's
you're
a
not
different-
just steering the ship into new waters, but you're undoing things your predecessors did.
But don't, I mean, if the recent set of appointments had gone a different way, and if we had a court where Justice Scalia was replaced by Merrick Garland and maybe President Clinton instead of President Trump, does anyone here doubt that there would be significant overturning of cases because of a change in the personnel of the court?
No, I think Citizens United would have gone. I think Heller might have gone. I take that point.
Yeah. So, I mean, again, it's true that it would come as a result of changing composition, and maybe the same legitimacy type objections would be raised. But I mean, what do we expect new justices to do? Vote the same way that the old justice voted, just because that would look more legitimate? I just think Erin's point is right. It's like, if we get a new justice, the most we can ask of them is that they apply the law as faithfully as they can, consistent with their understanding of the law. And if that means that, you know, a case is going to come out differently than it would have come out otherwise, that's just the nature of having, you know, different people be on the court.
And I mean, don't get me wrong, it's not that there aren't, you know, discussions to have when there's a new justice about whether what they're doing is legitimate, but if you define legitimacy just in terms of like, there's new personnel and the court came out differently, I don't see how that really gets you anywhere. It has nothing to do with the substance of the decisions and whether they're actually getting to results for particular reasons.
So does the concept of legitimacy do any work? What does it mean?
I guess I do.
Well, it seems to me that the Chief Justice and Kagan have two very different concepts of what it means to have legitimacy and what it means to be legitimate. And Justice Kagan is sort of affiliating this with, you know, a lack of partisanship or the appearance of nonpartisanship. And the chief is focusing on how you do your job. Is it legit? Are you doing law as opposed to something else? Are you applying the law? Are you applying your vision of the law? And, you know, I think that's where they part ways. They're two different understandings of what it means to be legitimate.
Can I just jump in? Oh, sorry. No, Jeff.
Oh, just real quick, you know, to play off Melissa, I think that's right. I think it's, are you doing law or something else? And the bottom question, I think, is, so, you know, what gives the court the right? Like, why do we follow the court and accept its judgments as an unelected institution? I think that's the bottom question. And I mean, I think of when is the court legitimate? I think of Al Gore when he went on TV and said, "I disagree with the court's decision, but I accept it." And now I think what's ultimately at stake with the legitimacy conversation, I think, is, you know, what happens when somebody says, you know, the court's decided that, that's all well and nice, but I'm just not going to do it. And I think that's what legitimacy is about. And that's what I think to the extent to be concerned, that's what I would be concerned about.
Yeah, so that's what I've always understood legitimacy ultimately to mean. Will people follow what the court says? And we're a long way from that. Yes?
Melissa seems almost there.
I think you have to, it's not just about the decisions that the court has done. I mean, it is the entire sort of panorama around the court right now. I mean, I think it's been a while since we've seen a spouse of a sitting justice exchanging text messages with the chief of staff of a president who is contesting the outcome of an election that, you know, the litigation around which is likely to go before the court on which her husband sits. And you know, I don't know if there's anything there. I don't know if it means anything that she's sending text messages to Mark Meadows, but any legal ethicist worth her salt would tell you that it doesn't matter if there's anything substantive there. It matters about the optics. The optics are what matters in terms of the way people perceive the court and the court's legitimacy. And it's not just about the cases, it's about all of this. This is a curio cabinet of weirdness right now.
A couple more questions, and I want to turn to the audience's questions, including the remote audience. I can't help but think John Roberts is not particularly happy. When I watched the video of him at the 10th Circuit Judicial Conference, he seemed out of sorts. And I I mean, his attempt to pick up a single vote for what probably a year ago we thought was the likely outcome in Dobbs, which is, uphold the Mississippi law, 15 weeks. We'll get back to you later on the other stuff. I know two of you have clerked for the chief, so let me ask you. He was just a couple of terms ago, the median justice, both the chief justice and the median justice, the first time since 1937 we have that. He's now in a different spot. How do you think he leads a court on which he's outflanked by 5 justices to his right?
I've never been totally convinced the chief wanted to be the median justice. I mean, I think the chief, I think he likes being able to have some control over where the court's going. I think it probably, he likes to have some control over what cases they take. I think the chief is very unhappy about the leak. Some of those dynamics, but like, I'm not sure it's in his mind the worst thing in the world to have to be kind of, look, I can't stop this and I can write my concurrence and now I can just kind of be there. And like, I'm sure I mean, the big thing that this was all about has now happened. Like it's happened. It's, we don't have to have every single case be about are they going to overrule Roe? Because they did it. So
that's a weight off his shoulders.
It really has been such, I think it's been such a driver in so much of what's been going on in terms of who's going to be on the court, what the court's going to take, all of that. And like, I don't know that, it's like the absolute worst thing in the world for him to not have to be kind of perceived. I don't think he ever wanted to be perceived as like a swing justice. I don't ever think he really kind of was fairly thought of as a swing justice. I think it's driven by some other dynamics that are quite different from how we've normally thought about that term with other justices. I don't know, Ramon.
Ramon, your thoughts?
Yeah, I'm not sure. I'm not sure I have much to add to that, except I guess I would say, the chief became the median justice in a very weird set of historical circumstances that could have easily turned out a different way. And I think that sort of assessing his leadership of the court with that as the baseline is kind of unfair to him in a way, because it's, he was really, for a brief moment there, he was in the position where he was not only the chief and had all the trappings and authority that comes with that, although there's not a ton, but he was also the median justice, so everything was concentrated in one place. So I think it inevitably, just because of the shifting composition of the court, he's not going to be able to sort of have his way in the way he would have been. But I don't think that's like a sign of his, his inability to lead or anything like that. I think he will be a good leader for the court the way he's always been. And if that means that he's dissenting or concurring sometimes, that's okay.
I mean, are there questions from the virtual world? Is there a question from Ellie Larson?
Yeah. Your thoughts on, were you surprised that the Dobbs draft and the ultimate Dobbs opinion were so similar? So thinking back to Jeff's worry about having them separate and not deliberating as much or moderating each other, were any of y'all surprised by that? No.
I think it made clear that in the cases that matter, like they're not necessarily swayed by the deliberative process and the exchanging of drafts between chambers. I mean, there were some minor changes, mostly to add in cites to the dissent and the concurrences, but nothing major. I mean, it pretty much tracked all the way through, and I wasn't surprised by the substance of the draft when I saw it, and I wasn't surprised that it didn't change at all. I mean, there is a kind of I guess conceit might be the word, but I mean, just such a clear vision of rightness and being unwilling to bend. I mean, there was a lot of crowdsourcing that went on after the draft opinion was released. And, one of the things I might have thought was that you would have gone back and maybe shored up some of the parts of the opinion that had been subject to critique, including some of the historians' take on what is, I think, a quite selective and misleading history. But there was none of that. Like, Samuel Alito, PhD in history, reporting for duty. And, there you are.
But that's precisely what's so damaging about the leak. I mean, it itself impacts the process. So you could never know if that had any impact on well, is it going to look like I was listening to crowdsourcing if I make some changes as opposed to a deliberative process? I mean, we just don't know. And I think that's what makes it, just one of the many, many reasons.
That's a fair
Sure.
point, but if I recall, the draft was dated February.
Yeah.
The leak came in May. Even in that period of time, even before the crowdsourcing, you'd think it might take some.
Well, not necessarily, just because of the way the back and forth
Yeah.
works with having to wait for a dissent. We don't know the timing of when various opinions came out, and like you often wait for that before you're going to start making changes in the opinion. So it's just hard to know.
Other questions? Yes.
I thought Ms. point about siloing and the ideological allegiance of clerks to their justices. I fear this week will have a doubling effect on the pathways for left-leaning would-be clerks to the federal judiciary. And after the wave of Trump appointments, it's obvious it's split, that might be even more apparent, especially when the former Supreme Court is court. I say all this because federal appeals judge last week told us the league in particular eliminated the chance that he would hire a liberal clerk in the future. So what consequences would you foresee there on a generation of future progressive scholars, advocates, and members of the
That's a great question. Does anyone want to field it?
I think judges or justices are going to be more careful about who they hire, and they're going to feel like they're taking more of a risk if they hire someone who is not going to agree with them, because incidents like this, I think, erode trust. I think the reality at the Supreme Court is that, and I'm very happy to be corrected on this, but I think the Democratic appointed justices that I've been familiar with and sort of seen, I think it's extremely rare that they would hire a clerk who is not either totally non-ideological or on the left. I think there's much more diversity in the hiring among some of the conservative justices, not all of them, but some of them. And so, to the extent that there's a change, maybe it makes it harder for a liberal clerk to be hired by a conservative justice. And they're basically in the position that the conservative clerks have been in for a while.
And of course, the premise of the question was that it was a clerk,
Right.
and that it was a liberal clerk, and neither one of those things is established nor obvious. Yes.
Yeah, we had a virtual participant ask, to what extent did the panelists think passage of SB 8 in Texas influenced the court's decision to overturn Roe instead of adopting Roberts' compromise positioning of 15-week national limit? Were the justices worried that such a compromise would have little effect if states would just pass bounding laws like SB 8 would the court have overturned Roe?
I
talked about this before.
Yeah, I do think SB 8 played a real important role. I think there's been some reporting on this by some of the people in this room, if I'm not mistaken, but the oral argument in Dobbs in some ways seemed like it was coming too late because the court had already hashed it out through the lens of SB 8. Now, I don't know that for sure, and maybe we'll never know. But I think that definitely, there was a confluence there in a way that the proceedings had to play out. And I think more generally, having worked on the case with the clinic side of the V, one thing we took away in some ways was if we persuaded the court of anything in our brief, it was that a decision discarding the viability rule and leaving for another day what to do would have just caused utter chaos and devolution. And the summer we just had would have looked a lot different. I think there would have been, we've been talking about all the 30 shadow docket cases on the Supreme Court from state after state with 5 weeks, 5.5 weeks, 6 weeks, et cetera. So I do think the court was, the Texas case keenly focused the court on that problem, I think.
Yeah, and I think it's less the bounty law nature of it than the this isn't gonna, it's not really gonna give us, we can't buy much time. And especially if you take that kind of against the history of where, I think there was a sort of hope they'd kick Obergefell down the road a couple more terms than actually happened. And, you've got a history showing, look, this is gonna be forced, and the dynamic of whether it's to bounty laws or anything else, this isn't going away. To me, I agree that it probably got the court going where it was probably going to go anyway, faster.
Mm-hmm.
Yes. Yeah, this member of the panel is pro-leak.
I think, I mean, look, I think it's a tough question. It's a tougher question. I think obviously it's a matter of national significance. We have a free press in the country and it's really important to get things out there. On the other hand, I tend to think that in this context and in other contexts, the judicial process is sacred in a sense. And I think the idea that like reporters should be reporting on judicial proceedings in the same way that they report on every other proceeding is probably not the right approach. I wouldn't want reporters showing up at a juror's house and figuring out what's going on in the middle of a big murder case. I wouldn't want jurors trying to pump law clerks for information on all the other non-abortion related cases. So I think there are some unique questions there that if you generalize this case to every other case, I think would pose some real problems. I obviously understand why Politico did it. Good clicks.
Judge Newsom.
So I'm, I guess, blocking and tackling question of methodology, and it's sort of rooted in Bruin. So maybe Erin can start, but I'm interested in what any of you think. So pre-Bruin, and I'm not doubting myself here because I've written this opinion. So pre-Bruin, I wrote an opinion that said, in the Second Amendment context, it looks like, you know, we ought to do just sort of technique. But I said separately, boy, but that's awfully different from what we do in other areas. And like, for instance, the First Amendment, there are tiers and tiers upon tiers and balancing tests and two different kinds of intermediate scrutiny, and it's mind-boggling to the lower court judge what he or she is supposed to do. And so I was a little surprised when the court says, textual history, and hey, this is how we do it in other areas of the law. See the First Amendment. I was like, what? Not as I say, as a middle manager. That's not the way I see First Amendment doctrine. And I'm just curious about what you guys think about what, if anything, that line portends for other areas.
Yeah, I think it's a super interesting question because, like, there are some areas. I mean, I think in some areas of criminal law, the court has come at things a little bit more that way. And you could say in some areas of First Amendment law, the court's been moving more that way. I do think if you follow not just this terms, but kind of the trajectory that got us where we ended up this term in the Establishment Clause, that the court has been moving more and more in sort of a historical understanding of the Establishment Clause. But really, the obvious huge outlier is free speech. And really, you know, huge aspects of free speech doctrine are not just, you know, kind of not historically grounded in the sense that that's not what they were thinking about, but like probably not historically grounded at all if you went and did some of the historical analysis. And, you know, at the same time, you have this court right now that, I mean, the one thing that it's been extremely committed to for such a long time is free speech and really a kind of free speech exceptionalism. I think this is going to be a really interesting term in putting some of that front and center, both in cases they already have and cases they may have. But you know, there's certainly an interest. I mean, if you just look at like the 303 creative reply brief that was filed this week or last week or whatever it was, there's sort of a Bruin discussion in that context. And I think there'll be efforts to push that way, but boy, you'd have to throw out like almost the whole body of free speech law to start over and do it in text, history, and tradition, other than, you know, one of the founding blocks of Bruin ultimately was like the Stevens decision saying that when we think about what kind of speech gets no protection at all, we're going to look at that as a historical matter. So maybe that's where you first start to see the court like creep a little bit that way. But you know, there's a lot of baggage that would have to go to really shift the First Amendment doctrine that way.
Can I say something just about the shift toward history and tradition? I mean, again, I just want to emphasize this is a group of 9 people, none of whom has been formally trained as an historian. And I think you see that in the way they've done history this term. Like a lot of it is selective, a lot of it leaves out historical moments that don't necessarily work in favor of whatever the outcome that they are going to reach. And it's just sort of left by the wayside. I also think it's going to change the dynamics of argument. And I think you, Ali Larson, are going to have a lot of work to do because I think it's going to make the work of amici even more important. And you're going to have these dueling amici with 2 dueling historical narratives fighting for primacy at the court. And there's not really going to be a good way to weigh the veracity of the history and those facts, especially from a court that is not especially expert in it.
I'm going to read just a quick passage from Thomas's opinion in which he says, you got to reason by analogy to historical examples. And then there's this bit that sounds like it's from Cat in the Hat. For instance, a green truck and a green hat are relevantly similar if one's metric is things that are green. They are not relevantly similar if the applicable metric is things you can wear. Okay.
Justice Thomas, PhD, reporting for duty.
Maybe we'll take one more question and call.
Could I just add one thought to the tradition and history and why it inserted itself into, I think, at least one reason. And again, I'm focusing on Justice Kavanaugh here, and where it might not necessarily translate into other areas. I think he would think compelling interest is too tough for this particular right, whereas intermediate scrutiny is too soft for this particular right. And so I think he, what tradition and history gives you is more flexibility in the middle, so that you can uphold some things that make sense, but don't satisfy compelling interest, and you can strike down some things that don't seem to make sense to him, that would be upheld under intermediate scrutiny, or at least how it has been applied traditionally. And I don't think that necessarily carries over to the First Amendment, where things may be working out basically the right way for almost everyone. The compelling interest test basically gets rid of anything that's in the compelling interest box. There's, 2 exceptions in history. And then the rest of it is incidental effects on that gets it into the intermediate scrutiny, and mostly that means it's upheld, except in this new area that of speech that's I don't know what to call it, but it's election related or confidential speech, in which case you can apply intermediate scrutiny and get rid of it anyway. So I don't think there'll be a big appetite, because I don't think they're going to see the First Amendment area as needing all that much revision in terms of the outcomes.
Except for doing away with Sullivan.
No, I don't think that's happening.
All right, but maybe we'll have one last question. Yes.
Differences you're going to see, not just in the general ideology happens, but how Justice Breyer's departure and injustice kind of come up.
Hypothetically. And my impression is that Justice Breyer was enormously effective and in sort of helping forge compromises and helping bring over, whether it was Justice Kennedy or the Chief Justice in certain cases. I think he, was very legitimately, sincerely liked by some of the conservative justices. They got along with him, and they felt like they could have good conversations with him. And my impression is that he was pretty effective. And so I think one question is there someone else who can play that role? Or, as Irv pointed out, some of the rhetoric is getting a little hotter these days on that side. And so is that going to be an impediment to someone playing the Breyer type role going forward?
And the other thing I would say is I'm not sure there's anybody left on the court who I would think of as such a unabashed pragmatist, and it's a little unfortunate to lose that at a moment when the court is when you're already sort of losing that, to lose the person who brought that perspective, and I'm not saying it's a perspective I always appreciate it, but I think it's a useful thing to have in the dynamics of the court and the justices. And it's a little unfortunate at a moment when everything is, as heated as is to lose somebody who kind of brought that way of thinking to cases.
And crazy hypothetical.
Well, yes. Argument will be way less fun for the people listening.
Imagine there's a spaceship.
All right. This has been great, very rich, lively discussion. Please join me in thanking the panel.
After one of those other roads.
Okay,
Different set of.
we're gonna break for the evening and we'll see you in room 119 tomorrow morning, 9 a.m.
Remember
No.
the original.
I think it was about the follow-up question. That much.
You could not have
That's more recent.
I think
Earlier.
I think that's like two stratos ago or whatever. No, I.